Any day now, the Supreme Court is expected to rule on a case that could have far-reaching implications for the unhoused across America. John Blackstone reports on what's at stake.
With foothills rising above, Boise, Idaho is a place of beauty. But it's the city's less scenic quarters, dead ends and back alleys, that were Robert Martin's home on and off for 15 years.
Just sitting here about like so, and had a blanket wrapped up, had it laying down underneath me as a little bit of cushioning between me and the ground, and just trying to catch a few winks.
On nights when Boise's homeless shelters were full, Martin got sleep wherever he could.
There were times I've slept in garage stairwells on cement, slept in rock, up under overpasses on the rocks and dirt.
But in Boise, sleeping or camping on public property was against the law. Martin was one of many ticketed and fined for sleeping in public.
And Robert's case was, I thought it was a vivid portrayal of the situation that homeless people find themselves in.
Howard Beladoff of Idaho Legal Aid Services saw a constitutional issue in Boise's camping ordinance and made a federal case out of it.
Here's a guy, he has no place to sleep. He's been walking around all night because he's been warned you can't, quote unquote, camp, which just means you can't have a blanket around you.
In 2009, in federal court, Beladoff filed a lawsuit that came to be known as Martin versus Boise, arguing that the city of Boise had violated the Eighth Amendment of the Constitution's ban on cruel and unusual punishment by leaving those without homes nowhere to legally sleep.
It's cruel and unusual in the true sense of the word, because every single one of us, rich, poor, old, young, male, female, they need to sleep.
9 years later, the Ninth Circuit Court of Appeals, based in San Francisco, agreed with Beladoff, writing it considered whether the Eighth Amendment's prohibition on cruel and unusual punishment bars a city from prosecuting people criminally for sleeping outside on public property, concluding it does.
And the fact that the courts have crippled our ability to do our jobs to help get people into shelter is criminal.
San Francisco's Mayor London Breed blames Martin versus Boise for worsening the city's crisis. A court order bars San Francisco from clearing sidewalk encampments unless it can guarantee a place to sleep for everyone it moves, a challenge in a city with more than 8,000 homeless but fewer than 4,000 shelter beds. Nationally, there is a lack of shelter beds. By one estimate, about 188,000 more people need shelter than there are beds available. But the Martin versus Boise decision applies only to the 9 western states under Ninth Circuit jurisdiction. In the rest of the country, 14 states have laws making it a crime to camp in public places, and 27 states have laws against vagrancy and loitering that can be used to move along those sleeping in public. Those kind of laws have effectively been outlawed in Ninth Circuit states.
What the Ninth Circuit has said is that a person can't be punished for being homeless if there aren't adequate shelter beds or places for them to go.
Erwin Chemerinsky is a leading constitutional scholar and dean of the law school at UC Berkeley. The Eighth Amendment prohibition on cruel and unusual punishment, we think of it as being applied to death penalty cases, for example. How can it be applied to homelessness?
In 1962, the United States Supreme Court said it's cruel and unusual punishment to punish somebody for a status. In that case, they said you can't punish somebody for being a drug addict. You can punish them for taking drugs, for possessing drugs, but not for the status of being addicted. Likewise, the Federal Court of Appeals here has said you can't punish somebody for the status of being unhoused.
Needing more affordable housing.
Since the unhoused can't be denied a place to sleep, Mayor Kate Collin in San Rafael, California, is almost powerless to move the person living in a tent beside City Hall. Shelters here are usually full, which means this suburban city of 60,000 can legally do little about encampments on its streets.
Every time we passed an ordinance, we were sued, either immediately or within the time frame that could happen.
It must be frustrating to try to say to residents here, sorry, we can't move the people who are camped at the end of your street because the court has told us we can't.
It is frustrating. People don't want to hear that San Rafael doesn't have the independent ability to work with our unhoused community. So when we say it's because of the federal law, it takes people a moment to say, really?
While many cities complain about Martin versus Boise, Grants Pass, Oregon is doing something. The city appealed to the Supreme Court. When the case was argued in April, advocates for the unhoused demonstrated outside the court, while inside, attorney Theane Evangelos, representing Grants Pass, urged the justices to overturn Martin versus Boise.
It would be a disaster if Martin were to remain on the books in any form.
How did Grants Pass, Oregon, population about 40,000, become central to this case before the Supreme Court?
It was sued by a group of plaintiffs who claimed that it would be cruel and unusual punishment for Grants Pass to enforce its local camping ordinances.
The Supreme Court decision expected this month could impact homeless policy across the country.
All of us living here within the Ninth Circuit have seen the effects firsthand of these decisions. And that's why if the Supreme Court were to agree with the Ninth Circuit, those conditions would spread to the rest of the country, and that would be the opposite of solving this problem.
On the other hand, I think there's such a compelling argument on behalf of what the Ninth Circuit said, that you can't make something a crime if there's no alternative.
What's on the line in the Supreme Court in this?
For homeless people, the question is, are they going to face criminal punishment because they don't have else to live? For cities, the question is, what can cities do lawfully to deal with their unhoused population? And for the Constitution, the question is, what's this going to mean for the Eighth Amendment?
Robert Martin no longer lives on the streets, but his thoughts remain with those who still search for places to sleep.
Being homeless should never equate to an unlawful act. Being homeless is an unforeseen and an unfortunate circumstance.
For Howard Beladoff, the attorney who started it all, the case is not only about the rights of the homeless, it's also about their humanity.
They feel so powerless because nobody listens and nobody cares. For the first time, they feel like they're a person. And they're recognized.